Welcome back, everyone. Today's case brings together a series of unusual developments. We're looking at a defendant who identifies with sovereign citizen beliefs, chooses to dismiss her attorney, and then decides to represent herself in a probation violation matter. It's a combination that makes for a complex and unpredictable courtroom situation. Let's take a closer look at how it unfolds.
State versus Ashley Clark, 22 CR 216. Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
I'll handle this myself, a phrase that often sounds confident at first, but can carry serious risks in a legal setting. In this case, the defendant chose to dismiss her attorney, despite the fact that a negotiated agreement had already been arranged on her behalf. Instead of moving forward with that deal, she decided to reject it and represent herself during a probation violation hearing. It's a decision that significantly raises the stakes and adds another layer of uncertainty to an already serious situation.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them. But you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well. And that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want to contest the hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay. State has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right. Ms. Clark, any opening statement?
No.
There's a certain level of confidence on display here, even if it may not be grounded in the realities of the situation. In a courtroom setting, that kind of approach can quickly lead to serious consequences. At this stage, the prosecution keeps things straightforward and calls its key witness, the probation officer, whose testimony is likely central to the case.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes.
And what was the result of that UA sample from Miss Clark?
It was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
It raises an important question about where these ideas come from and how they're applied in real situations. Many of the sources promoting these beliefs focus heavily on rejecting legal representation, but offer little practical guidance on what comes next. As a result, individuals who follow that advice often find themselves navigating a complex legal system without the tools or knowledge needed to do so effectively. Court procedures require structure, evidence, and an understanding of the law, things that aren't easily replaced by unconventional theories. When someone takes on their own defense without that foundation, it can lead to outcomes that work against their own interests rather than helping their case.
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
This next part should be telling. So far, the defense strategy has been noticeably limited. There's been no challenge to the state's evidence and no effort to present an alternative case. That makes the closing argument especially important, as it will likely reveal how the defendant plans to justify her position after offering little in the way of formal defense to the stage. It becomes a clear test of whether there's any structured argument to support her case, or if the lack of preparation will ultimately speak for itself.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide first-hand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
There's a common saying about focusing on the wrong issue, and that seems to apply here. The concern being raised doesn't actually match the situation at hand. This case isn't about a federal agency, it's the state bringing forward the violations, which makes a significant difference in how the matter is handled. To this point, the decisions have been made and the strategy has played out. Now, it comes down to the outcome and what the court ultimately decides based on everything presented.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
That's quite a claim. Placing a dollar amount on every minute spent in custody quickly adds up, at least on paper. But in reality, those kinds of arguments rarely hold weight in court. What this situation ultimately highlights is a simple point. having qualified legal representation can make a significant difference. Choosing to proceed alone, especially without presenting a clear defense, often puts a person at a serious disadvantage. And with that, we've reached the end of today's video. If you found this breakdown helpful, feel free to leave a like. If not, you can share your thoughts as well. Don't forget to drop a comment and subscribe with notifications enabled so you don't miss future updates. This is Team Skeptic, signing off.